Welcome to Torts and Truth. This is your decoded advocate. Right now, if you have an active personal injury claim, there is a letter heading toward your mailbox. It arrives looking routine, it arrives looking medical. It uses the language of healthcare and professional courtesy. Inside, it contains an appointment time, a doctor's name, and an address. The insurance company calls this an independent medical examination. There is nothing independent about it. That doctor is not your physician. That doctor does not work for you. That doctor has never met you, has never tracked your recovery, and will spend less time examining you than it takes to eat lunch. But that report, written in clinical language by a doctor who is paid by the insurance company, is designed to do one thing: close your claim, reduce your settlement to zero. Today we are going to open every page of this process. What it is, how it works, what that doctor is actually doing during your appointment, and the exact steps to protect yourself before you ever walk through that door. Because most injury victims never see this coming. The ones who do, win. An independent medical examination, referred to in legal and insurance documentation as an IME, is a medical evaluation requested by the insurance company after you file a personal injury claim. In many states, insurance companies have the legal right to require you to attend one as a condition of processing your claim. That word, independent, is one of the most strategically chosen words in the entire insurance industry. It implies neutrality. It implies objectivity. It implies that a credentialed medical professional will evaluate your injuries and deliver an honest medical opinion. Here is what they will tell you. This is a standard procedural step. A qualified doctor will review your injuries to help determine the appropriate level of compensation. It is routine. Here is what they will never tell you. The doctor who examines you is selected from a short, pre-approved list of physicians who regularly perform IMEs for insurance companies. Their medical practices generate substantial annual revenue from insurance referrals. In documented cases, individual IME physicians earn between $400,000 and $1 million per year, performing examinations almost exclusively for insurance defense purposes. That financial relationship is not disclosed to you in the appointment. Understand this one fact, and everything that follows will make complete sense. An IME doctor is not your doctor. They are a retained expert. In litigation, a retained expert is a professional whose opinion is purchased by one side of a dispute. Insurance companies retain IME physicians the same way they retain defense attorneys. They are on the same team. They are paid from the same budget. And their continued access to IME referrals depends, in practice, on the consistency of their conclusions. A study examining workers' compensation IMEs found that physicians performing insurance company-requested examinations found in favor of the insurance company in over 80% of cases. Read that again. More than 80% of the time, the doctor insurance sends concludes that your injuries are less severe than your treating physician documented, or that they are not related to the accident at all. This is not a coincidence. This is not medicine. This is a business arrangement operating under a medical license. Your treating physician has examined you multiple times. They have reviewed your imaging. They have tracked your recovery across weeks or months. The IME physician will have access to some of those records, but they will see you exactly once. For an appointment that lasts, in many documented cases, between 8 and 20 minutes. Tactic 1. The 8-minute evaluation. Your treating physician has spent hours with you across multiple appointments. They have watched your condition evolve. They have adjusted your treatment based on your response over time. The IME physician conducts a single examination, often lasting less than 20 minutes, and produces a written report that directly contradicts months of documented medical treatment. Courts and insurance companies permit this because it technically meets the legal definition of an independent medical opinion. What it does not meet is any reasonable standard of comprehensive medical evaluation. How to protect yourself. Document the actual duration of your examination from the moment you enter the room to the moment the physician concludes. Write it down immediately after you leave the building. This documented discrepancy between exam duration and report claims is one of the most effective tools your attorney can use to challenge an IME in litigation. Tactic 2. The language architecture. IME physicians are experienced in the specific vocabulary of insurance defense medicine. They do not write that your injuries are fabricated. They do not write that you are lying. They write that your subjective complaints exceed the objective clinical findings. They write that the findings are inconsistent with the mechanism of injury described. They write that there is no structural explanation for the level of disability reported. Each of those phrases is a legal instrument. Subjective complaints exceeding objective findings means you are describing more pain than the doctor could physically verify in a 15-minute exam. Inconsistent with the mechanism of injury means the nature of the accident does not typically produce injuries of this severity. This is a direct challenge to causation, the legal link between the accident and your injury. No structural explanation for reported disability means the doctor found no physical evidence of the limitations you are living with every single day. None of these phrases require the doctor to call you dishonest. They simply require a pen and a vocabulary. How to protect yourself. Request a copy of your IME report as soon as it is generated. Your attorney can secure a rebuttal evaluation from your treating physician that directly addresses the specific clinical language used in the IME report. A rebuttal is one of the most powerful counter tools available. Here is the part that changes how you understand everything you have just heard. IME reports follow a predictable structure. Not because medicine is predictable, because the conclusion is built into the format before the examination begins. Independent legal reviews of large samples of IME reports reveal patterns that are statistically impossible to produce through neutral clinical judgment. IME physicians retained by insurance defense firms deny or minimize injury claims at dramatically higher rates than independent physicians reviewing the exact same medical records. The structure of the report is designed to reach a destination. That destination is reduced liability for the insurance company. Tactic 3. The pre-existing condition search. Before you step into the examination room, the IME physician has reviewed your medical records. All of them, if the authorization you signed was broad enough. They are looking for one specific piece of evidence. Any documented medical history that can be used to argue that your current injuries existed before the accident. A prior back pain complaint, even once, even 5 years ago. A prior knee injury, even if fully resolved. A prior history of headaches, even if unrelated to this accident. Each one becomes a line in the report. Each one becomes a legal argument. If the accident aggravated a pre-existing condition rather than caused a new injury, the settlement value of your claim is significantly reduced under most state laws. How to protect yourself. Before your IME, sit down with your attorney and review exactly which medical records were provided to the examining physician. Ensure that the authorization you signed was limited to accident-related treatment only. If a broad authorization was already submitted, your attorney can file objections and request corrections to the record set before the examination takes place. Tactic 4. The behavioral observation. The examination begins the moment you arrive in the parking lot. IME physicians and their staff are trained to observe your behavior before, during, and after the formal appointment. How you exit your vehicle, how you walk across the parking lot, how you sit in the waiting room, how you reach for a pen to complete intake paperwork. All of it is subject to notation. If you park 2 blocks away and walk to the building, that walk is observed. If you sit in the waiting room without visible signs of discomfort, that is noted. If you grimace during the examination but appear comfortable in the hallway afterward, that inconsistency becomes a line in the report. How to protect yourself. Behave during the examination exactly as you behave at home. Do not perform your injury and do not minimize it. The only medically and legally defensible presentation is an honest one. Move within the limits your injury actually creates. Nothing more and nothing less. The question most claimants ask at this point is whether they can simply refuse to attend. The answer requires precision. If the IME is requested by the opposing party's insurance company, and you have no contractual relationship with that insurer, your legal obligation to attend may be limited, depending on your state. If the IME is requested by your own insurance company under a policy you hold, your policy's cooperation clause may obligate you to attend. If your claim has entered litigation, The court may order an IME under civil procedure rules, and refusal to comply can result in sanctions, including dismissal of your claim entirely. Refusing without legal counsel is one of the most damaging decisions you can make. An unadvised refusal hands the insurance company exactly what they need to challenge your claim's credibility. It gives them a procedural argument that is entirely separate from the merits of your injuries. The correct response to an IME request is not refusal, it is preparation. There are 4 non-negotiable steps before any IME appointment. Step 1. Do not respond to the IME request without legal representation reviewing it first. Many states permit you to have an observer present during the examination. That right must be exercised before you arrive, not after. Step 2. Have your own treating physician document your current condition and functional limitations in writing immediately before the IME date. A contemporaneous physician note creates a direct clinical comparison to whatever the IME report produces. Step 3. Keep a daily symptom journal from the date of your accident forward. Consistent, dated, first-person documentation of your pain levels, physical limitations, and medical appointments creates a credibility record that no single IME report can erase. Step 4. Request the IME report in writing as soon as it is produced. Compare it line by line against your treatment records. Every factual inaccuracy is a challenge point. Every clinical claim that contradicts your documented history is grounds for a formal rebuttal. Here is the decoded truth about the independent medical examination. It is not designed to find out how injured you are. It is designed to produce a document that justifies paying you less. The physician who examines you is operating inside a system with financial incentives that run in one direction only. Your treating physician documents your reality. The IME physician documents their client's position. Knowing the difference before you walk through that door is the difference between a fair settlement and a denial letter. Consult with a personal injury attorney before you respond to any IME request. Most offer free initial consultations and work on contingency, meaning you pay absolutely nothing unless they recover compensation for you. The cost of a consultation is zero. The cost of walking into a professionally orchestrated process uninformed could be your entire claim. If you missed our last video on the 7 tactics insurance adjusters use from the moment your claim file opens, the link is in the description below. Watch it after this one. This is your Decoded Advocate, and I will see you in the next one.